Good morning. My name's Emma Wisby. I'm the meeting facilitator for this licensing subcommittee hearing decision announcement. Today is Friday the 24th of July. I'm also the legal advisor to the subcommittee. Members for this announcement are Councillor John Ball, Councillor Andrew Hensman and Councillor Peter Schweer. We also have in attendance Mrs Irwin, who is the applicant, and we also have Mr Laxton, who is an interested party who's made a representation to this application. We also have in attendance Jessica Mann and Alison Webb, who are governance officers who are taking notes for this meeting. We also have in attendance an officer who is performing the webcasting function. Before I hand over to the chairman, I would just like to ask each member in turn to confirm whether they have any declarations of interest or whether they've had any contact from any party regarding this hearing during their period of deliberations since this hearing retired for deliberation on Tuesday, the 21st of July. I'd like to start with Councillor John Ball.
I can confirm that I've had no contact with anyone about this and I have no interests to declare.
Thank you very much, Councillor Ball. Councillor Andrew Hensman.
Yes, Emma, I can confirm that I've had no contact and I also have no interest to declare. Thank you.
Thank you very much. Councillor Peter Schweer.
Emma, thank you. Yes, I can confirm that I've had no contact and that I have no interests.
Thank you very much. Members and Mr Laxton and Mrs Irwin, you will recall that we had a reserve member, Councillor Bill Rose. He was on reserve just in case there was a declaration of interest. I can confirm, although he did watch the giving of evidence at the first part of this hearing, he has not participated in the decision making and he is not present today because it's not necessary for his attendance for the decision making. I will now hand over to Councillor John Ball, who is the chairman of this licensing hearing. Thank you very much, Councillor Ball.
Thank you very much, Emma. The licensing subcommittee has read the material presented to it and has listened to all the evidence and submissions. In considering the provisions of Section 35 of the Licensing Act 2003, the statutory guidance issued under Section 182 of the Licensing Act 2003, issued April 2008, and Braintree District Council's licensing policy, the licensing subcommittee has decided to grant the variation to the premises license, which is S4/3 19/01279/LAD PS/LA for the premises as follows. The purpose of the variation application is to remove condition 10 contained within Annex 2, condition consistent with the operating schedule, which states the premises license holder, PLH, or the designated premises supervisor, DPS, or person instructed by the PLH or DPS and in a suitable position of authority shall ensure that the area is monitored to ensure that this requirement is being complied with and that loitering does not take place in the public front garden, with exceptions allowing access and egress to the public house. Public front garden shall be cleared of patrons or other persons, including staff, from 20 to 30 p.m. daily. So that's condition 10, which is being removed. Instead, the applicant has proposed the following restriction to support the variation application. To restrict the use of the front garden, May to August inclusive, Monday to Thursday and Sunday up to 10 p.m, Friday and Saturday up to 11 p.m. The premises license, as varied by the removal of condition 10 and the inclusion of the restriction set out above, is subject to the conditions offered by the applicant in order to promote the 4 licensing objectives as set out in Part M of their application, and all mandatory conditions and other conditions contained in the license. read this again, brackets S4/3, 19/01279/LAD PS/LA. I now come to the reasons for our decision. The licensing subcommittee is required to consider the application to vary the premises license as submitted in accordance with Section 35 of the Licensing Act 2003. Paragraph 8.57 of the statutory guidance issued under Section 182 of the Licensing Act 2003, April 2018 guidance states that in considering an application for the variation of a premises license, a licensing authority must consider any relevant representations received which clearly relate to the likely effect of the grant of the variation on the promotion of at least one of the licensing objectives. Paragraphs 9.42 and 9.43 of the guidance states that each application must be considered on a case-by-case basis, and that representations submitted by responsible authorities, other persons, and the applicant should be taken into account. In addition, paragraph 9.44 of the guidance states that the determination of whether an action or step is appropriate for the promotion of the licensing objectives requires an assessment of what action or step would be suitable to achieve that end. The licensing authority should consider wider issues, such as other conditions already in place, to mitigate potential negative impact on the promotion of the licensing objectives and the track record of the business. The decision of a licensing authority should be evidence-based, justified as being appropriate for promotion of the licensing objectives, and proportionate to what is intended to be achieved. The imposition of standard conditions should be avoided and may be unlawful where it cannot be shown that they are appropriate for the promotion of the licensing objectives in an individual case. In this case, the licensing subcommittee, having regard to the application and the representations made prior to and during the hearing, considers that it is not proportionate and necessary for the promotion of the licensing objectives to impose any further conditions. In considering this application, the licensing subcommittee has had regard to a representation submitted by a local resident. This representation is based on the effect of the application the effect of the application on the licensing objectives of the prevention of public nuisance and the protection of children from harm. However, as the Licensing Act 2003 stipulates that the objective relating to children only applies to children within a licensed premises, this part of the representation cannot be considered. With respect to the prevention of public nuisance, the residents' concern about the hours and nature of use of the area to the front of the premises and the removal of condition 10 of the existing premises license, restricting the use of the area to 8:30 p.m. each evening, would lead to unacceptable levels of noise and antisocial behaviour late at night. The residents' account of the history of the licensed premises indicates that there have been problems with noise, disturbance and antisocial behaviour in the past, and he is concerned about possible reoccurrence of such problems if condition number 10 was to be removed. The last complaint recorded against the premises was in September 2011, and there have been a number of licensees since that date. Thus, there is no reliable evidence as to whether the existence of condition 10 has reduced noise and antisocial behaviour, or if this has resulted from different management regimes. The licensing subcommittee acknowledges that the representation submitted is based mainly on concerns about the potential for noise disturbance, particularly raised voices and unsuitable language from patrons using the outside area at the front of the premises. However, the subcommittee have been advised that there have been no recent complaints to the licensing authority about noise nuisance at the premises, and that the volume of a person's voice is not something which can be controlled under the terms of a premises license. No objections have been submitted by the responsible authorities. It is noted that the premises license was transferred to the applicant on the 23rd of September 2019, and that the premises operated for a few months before it being required to close until early July 2020 in accordance with COVID-19 restrictions imposed by the government. The applicant intends to encourage good behaviour by patrons while discouraging inconsiderate behaviour. As part of the application to vary the licence, the applicant has offered to restrict the use of the front garden to the months of May to August inclusive each year. This, together with suggested hours of use, would reduce the potential use of this external space over a year to that currently available under condition number 10. Furthermore, the applicant has offered to take additional steps as set out in Part M of her application to promote the 4 licensing objectives, and these will become conditions of the license. Taking these factors together, the subcommittee is persuaded that they represent a proportionate response to address any concerns over the removal of condition number 10. The license, in a note to applicant, the licensing subcommittee welcomes the applicant's suggestion to erect signage at the front of the public house stating that the front garden is a quiet area and that patrons who wish to smoke, other than those who are seated in the area, should use the designated smoking area at the rear of the premises. The subcommittee also encourages the applicant to maintain contact with her neighbour in order to resolve any issues or concerns arising from the operation of the varied premises licence. That's the end of the decision. There are, of course, rights of appeal and rights to request a review. I shall hand over to Emma to read those out to you. Thank you very much.
Thank you, Chairman. Chairman, as you've referred to, there is a right of appeal to the Magistrates' Court, and any appeal must be submitted within 21 days to the Magistrate Court with a fee, and the Magistrates' Centre for receiving that appeal is at the Chelmsford office. Details of the appeal process will be set out on the written decision notice, which will be sent to all parties after the close of this hearing. There is a right to review, so if there is any concerns regarding the operation of the licence after this decision, then any person, not just persons to this hearing, may apply to the local authority to have the premises licence reviewed. This is a formal process which is engaged through an application process. However, we would encourage that if there is any concerns regarding the operation of the licence, in first instance, that parties do speak to each other in accordance with the request of this subcommittee. Chairman, each party to the hearing will receive a copy of the decision notice. We will undertake to have that emailed out to them this afternoon. If Mrs. Irwin or Mr. Laxton has any questions regarding the operation of the licence following this decision, then we would ask that they are directed to the licensing department. Because this is now a decision of the licensing authority and there is a right of appeal under legislation, I would ask that Mr. Laxton nor Mrs. Irwin makes direct contact with the members, and if you do have any concerns, they're either to be addressed to the licensing department or myself as the legal advisor. However, I must advise I cannot give you legal advice on the operation of the licence. That's something that you will need to take separately. Chairman, you have now announced your decision. I can conclude that there is no further matters that you need to undertake as a part of this licensing subcommittee. On behalf of the chairman, I'd like to thank Mr. Laxton and Mrs. Irwin in attendance. This is our first licensing hearing held by a virtual meeting, and I'm very grateful for your interaction and your participation in this matter. Chairman, I will now ask for the webcasting officer to cease the broadcast of this licensing subcommittee at 10:15.